Due Process, winner of 25 regional Emmy Awards, including the 2014 New York Emmys for our coverage of criminal justice and current affairs. Due Process is a presentation of Rutgers School of Law, Newark, and the Edward J. Blaustein School of Planning and Public Policy. Studio facilities provided by the Rutgers ITV Studio, Division of Continuing Studies.
In the words of Yogi Berra, it's like deja vu all over again at the nation's highest court. The hot cases on the docket, once again, gay marriage and Obamacare. What you need to know and what's really at stake on our annual Supreme Court update, up next on Due Process.
Major funding for Due Process provided by the Fund for New Jersey, supporting informed citizens for an effective democracy. Additional funding from the New Jersey State Bar Foundation.
If you've been following every case, every argument, every nuance of this year's Supreme Court session, you can skip this edition of Due Process. But if, like most of us, you followed just enough to be half informed and half confused, you'll want to stay with us. I'm Raymond Brown.
I'm Sandra King, and if you're a Due Process regular, you'll know it's become an annual event. Our midterm look at the cases and the consequences, the decisions made already and the big ones yet to come. And as always, we turn to the best court watcher we know.
Steve Shapiro is the National Legal Director for the ACLU. He and his team are actively involved in 20% of this year's high court cases. But for this event, he wears the neutral hat of the expert insider because if anyone knows the ins and outs of the court and the cases, it's Steve Shapiro.
And Steve, let's start with one that the ACLU is pivotal in, and that is marriage equality. It's back again.
It's back again, and hopefully for the last time.
2 years ago, in shuffling Prop 8 back to California, it ducked the question of whether, in fact, the states have to recognize marriage equality and the right of people of same sex to marry. Now it's back. Why?
It's back because I think events moved much more quickly than the Supreme Court ever anticipated, and that most of us, in fact, anticipated when they decided to duck the issue 2 years ago. I think they probably thought they were buying themselves another 5 years for the culture to adjust. But there were a series of court decisions unlike anything that I have seen in my career where somewhere in the neighborhood of 40 courts in the last 2 years have now struck down bans on same-sex marriage.
And then comes the Sixth Circuit.
And then comes the Sixth Circuit, which is the outlier, and upholds bans on same-sex marriage from 4 different states, from Kentucky, Ohio, Tennessee, and Michigan. What's interesting, though, about the Sixth Circuit decision, and it does demonstrate how far we have come, is even they didn't say it was particularly defensible. The opinion begins with the following line: who decides? And so it is all about the question of whether or not the courts ought to intervene or whether or not the political process ought to be allowed to play out. I think everybody has reached the point now of believing it's inevitable.
Well, in keeping with Sandy and Yogi Berra's theme of deja vu all over again, the question of the Affordable Care Act or Obamacare is also back before the court. This one turns on one phrase, does it not?
It turns on 4 words, and so to paraphrase, you paraphrase Yogi, I'll paraphrase Winston Churchill. Never has so much for so many turned on so few words. But let me just go back and say one other thing about marriage, if I could, because I think it's important for people to understand. There are actually 2 questions before the court, and the case will be argued at the end of April. The first question is whether every state in the country is required to actually license marriages, allow people to marry in their own state. The second question is, do states have to recognize valid marriages from other states? So if you live in a state that allows same-sex couples to marry and you then move into a state that does not, does the second state have to recognize the first? Generally speaking, the answer to that question, of course, is yes. You move across states.
Can you conceive of those two answers being answered in a manner adverse to each other?
I think if you win the first case, if the court says every state must license marriage, then recognition drops out. It's not really an issue. It is conceivable, I don't think likely, but it is conceivable that the court could say states get to choose whether or not to license marriages. But just as they said about the federal government 2 years in Windsor, right? Once another state has married you, the federal government has to recognize that marriage is valid, and your sister states have to recognize that marriage is valid. But one of the things that has happened, and then we can move on to Obamacare, but one of the things that has happened in marriage is not only have there been all of these decisions, which have overwhelmingly gone in one direction, but there have been literally thousands of marriages on the ground. And the Supreme Court was asked to put a halt to those marriages until it issued its final decision, and over again it said not. It said it wouldn't do that. So it has created a reality on the ground, and I think that one of the things the court is now confronting is if it were to consider sort of holding that this is a political issue, not a legal issue, the court's not going to be the decision maker here. There's going to be chaos across the country, and I don't think the court wants to be responsible for that degree of chaos. And the same issue arises in the Obamacare case. This is very different than several years ago, right, where there was really a frontal assault on Obamacare, the Affordable Care Act.
Would have been wiped out.
Would have been wiped out in its entirety, but would have been wiped out at a time before it was really in place. Now what we have is millions of people who are insured, and the prospect of doing something that will topple the House, right, and cause millions of people to lose
the House of Representatives or a metaphorical House?
A metaphorical House. That will cause millions of people to lose the insurance that they have grown to live with.
7 million at stake?
Yeah, I'm just not sure that the court wants to step into that mud pile.
But what's the phrase that's at issue?
So the question is, the way the Affordable Care Act was set up is that it is the whole theory of the Affordable Care Act is the way that we both ensure that more people get insured and make insurance affordable is to increase the pool of people who are being insured, and more specifically to increase the pool of healthy young people who are being insured because they don't cost as much for the insurance companies, right? And the Affordable Care Act, Obamacare, did that really in three ways. It did that first by saying we're going to penalize people if they don't sign up. Secondly, we're going to incentivize the states to increase Medicaid eligibility so more people will get insurance through Medicaid. And then the issue that is actually now before the court is the working poor, in essence. Those who don't qualify for Medicaid but can't easily afford insurance on their own are entitled to a federal subsidy to help them buy insurance. And the actual provision of the law that talks about the federal subsidy says the federal subsidy shall be available in health care exchanges established by such states, right? And so it's that phrase, established by such states, because we all know that what happened is many states, entirely, I think, Republican states, chose not to create their own healthcare exchanges, and the federal government then stepped in and created exchanges in those states. Right? And so the argument now becomes...
The majority.
The majority. The majority of states have federal created healthcare exchanges. The argument then becomes the federal subsidy program is not available in those states that have a federally created exchange because under the statute it's only available in those states that have exchanges established by such a state. And if you read those four words in total isolation and ignore the several million other words in the statute and the legislative history that led to the statute and the clear purpose that animated the statute, one could say maybe that argument has a certain amount of force, but it is totally acontextual. And if you read it as Congress evidently meant it to be read, it makes no sense, because if you pull out that subsidy, the whole house of cards, not the House of Representatives, the whole house of cards collapses.
Now, metaphors aside,
yes.
The issue here is, first of all, that there are people who argue there's a federalism issue at stake here. We often talk about it, and I think both lawyers and non-lawyers alike say, do justices on the Supreme Court ever put aside their jurisprudential ideas and look at consequences. And both the marriage cases that Sandy asked you about and King versus Burwell raised the question about whether the court is potentially looking at consequences, because there already has been oral argument in King v. Burwell, and some of the reports suggest that Justice Kennedy was both raising federalism issues but also showing concern about consequences.
And Justice Roberts said nothing.
Yeah. Yeah, he was quiet,
right,
except for one quip.
Mm-hmm.
But sure, they care about consequences, and they ought to care about consequences because they're not a debating society. They operate in the real world, and their decisions have impact in the real world. One of the things that I'm actually worried about, though, in King versus Burwell is Justice Kennedy, in the course of one of his federalism riffs during the argument, said, well, if we interpreted the statute the way the challengers are interpreting it, then effectively what the Congress would have been saying to the states is either you create an exchange or nobody in your state will get a subsidy. And for Congress to sort of create that, impose that threat, right, would be coercive on the states. And if Congress were to coerce the states in that way, it would create a federalism problem. So we're not going to assume that's what Congress did, and therefore we're going to assume that Congress meant the subsidy was available to every exchange, whether created by the state or the federal government. That wins the case, right? But it expands on...
Wins the case for proponents of Obamacare.
It wins the case for the Obama administration, right, and for proponents of Obamacare. The danger with that is it expands on something the court said in the first Obamacare decision, and that is when the federal government uses the power of its purse, which it does every day of the week, to try to influence state policy by saying we will give you funding to do X, but we won't give you funding to do Y, that it arguably violates federalist principles if they're offering too much money, because then it becomes coercive. So it is possible
but
that
talk
Obama...
about consequences.
It's possible
that would have an even bigger set of consequences.
That's right. So it's but they would be hidden.
Right.
They wouldn't be as immediately obvious. You wouldn't have people tomorrow losing insurance. So it's possible that what happens is Obamacare survives, but this is another decision where the seeds of a future mischief are planted in the footnotes of the opinion.
And who casts the deciding vote in favor, assuming that's the way it's going to go? Because Roberts did it last time. He didn't say much this time. What do we expect?
I think, well, let me put it this way. I went into the argument thinking that the law was in real jeopardy. I came out of the argument thinking the law might barely survive. If the law survives, my guess is it survives 5-4. And my guess it survives this time with Kennedy being the swing vote and not the Chief Justice. That would be my guess.
So let's go back to the marriage equality cases. I think there are people watching right now who are likely to be saying, wait a minute, wasn't all this decided 2 years ago? Because Windsor did take it on and won, and it was a great success for you and the ACLU, and yet it didn't decide it all.
It did a lot. It created the momentum that produced the judicial results we've seen over the last 2 years. But Windsor did not require any state that hadn't already recognized marriages to recognize marriage. It just required the federal government to recognize a marriage once the state had already agreed to do so. Now we're facing the really more basic issue, which is what about the states that just don't want to recognize same-sex marriage at all? Are they obligated by the federal Constitution, by our understanding of what liberty means, the right to marry, the right to associate, and the right to equal protection? Are they obligated by those constitutional principles, whatever they might choose to do politically, to say same-sex couples have the same right as different-sex couples to get married? That wasn't decided in Windsor, and that's the issue that the court's going to have to decide this year.
But now that the Supreme Court cannot duck this any longer, it is squarely on their plate.
I think it's unlikely. They're very creative but ducking things, but I don't think they will.
Let me ask you one other question.
I wanted to get to, now that they can't duck it, so what happens?
I think we will.
Any chance that they would reject?
Look, there's always a chance. I think it's a mistake to ever go in and think there's a foregone conclusion here, right? They could rule against it, but it would be very, very surprising, and especially, as I said, very surprising in the way that they have let events unfold over the last 2 years when they could have press the pause button, and they chose not to do so, right? So now they have to deal with the momentum that has been created in the interim. So I think by the end of June, this issue will be over, and I think the American public will accept it with equanimity, because I think the American public is already there.
Okay, now when you say the issue will be over, certainly I think everybody, including the court, has been shocked at the speed with which the notion of LBGT rights have been accepted broadly politically. There is a state called Alabama, and there is the ACLU, which is a national organization and has reaches everywhere, and there's been particular kind of mini interposition by the Supreme Court justice in Alabama. Do you see any kind of last-ditch resistance from that judiciary, which seems to have resisted as much as the space would allow?
You know, I maybe the Chief Justice of the Supreme Court, Roy Moore, is you know, I think will go down fighting. But I think he will go down if the U.S. Supreme Court resolves this issue. And I think it's been interesting what has happened in Alabama. If there was any sense that there were 10 other Alabamas there waiting in line, I think it might give the court some pause. But I think Alabama is standing alone in the schoolhouse door, as it were, in the wedding chapel door. And I think the Supreme Court, rather than seeing that as a reason to go slow, is going to see that as a challenge to their authority. And I think it's going to spur the Supreme Court rather than inhibit them.
I've seen an interesting piece that claimed that in fact this was going to be that a decision by the court, a positive decision by the court, was good for the Republicans as well as for those people who actually care about marriage equality, because it gets them off the hook before the 16 elections.
Yeah, I think that's right. I don't think anybody wants to be, any of the major parties wants to be seen as running on a platform opposed to same-sex marriage. I don't think there's any political
Isn't that
mileage
funny,
in that.
Given where we were 10 years ago?
It's you know, it's sort of astounding. And on one hand, I mean, I think it's important to say, on the one hand, the progress seems like it has moved at warp speed. On the other hand, we have to remember that there were several centuries or millennia where nothing happened, right? And the LGBT community still faces enormous discrimination in the society. And so one of the places that the conversation has already turned is in most parts of this country, there are not anti-discrimination laws that protect the LGBT community. So you can win the right to marry tomorrow and then get fired by your employer for having married somebody of the same sex, right? Or not getting the apartment that you want. And then this whole issue, which is playing out in Indiana at the moment, as we are taping the show, about whether there will be a religious exemption to anti-discrimination laws, and is that a matter of, you know, freedom of conscience, or is it a matter of a license to discriminate, which is the way we think about it. I think that's where, though, the public dialogue is going to move. I think we've just moved past marriage. We're there now, and you know, I think the Supreme Court will be willing to end that debate.
Let me ask you about Alanis. There is a really interesting development in the blogosphere. That is, the electronic communications. Two things. One, unrelated to Alanis, is that people are not understanding that it's a crime to steal email. But the other is the question of when a threat is a threat within the framework of electronic communications, hip-hop, and the law. Can you quickly tell us what Alanis is about legally and factually? Yeah,
Alanis is a federal prosecution of a defendant who engaged in, posted you know, what I think might be described as a fairly threatening series of blogs, primarily directed at his ex-wife, and then was arrested under federal law for having made threatening statements. And threatening statements are a crime, you know, whether you do them online or offline. And there are really two issues.
But I'm not sure culturally everybody's accepted that.
No, I'm you know, people think you can post things online, it doesn't have consequences, right. And you know, it has all sorts of consequences, right? But legal consequences among them. But the two legal issues, one is unique to online and one is not. The Supreme Court has said that people get to use harsh language, people get to use vituperative language, people get to use a provocative language, but you're not entitled to threaten people, right? And then the question is, well, how do you know when you've crossed the line? In a lot of places, and this is the federal government's argument in the case, if a reasonable person who was the target of your speech, if the wife in this case, right, reasonably understood that language to threaten her security, then it's a threat, right? And so it's an objective test. You look at how would the reasonable listener have interpreted this language, right? But there's also an argument, it's an argument that we support and that comes, interestingly enough, from Thurgood Marshall, that says, as with most crimes, you need to show not only that a reasonable listener would have interpreted the language as a threat, but you need to show that the speaker actually intended to make a threat. Because otherwise, there's too great a risk that you're turning over the government the authority to prosecute people for unpopular speech, right? So you need a mental element. You have to show the defendant intended it to be a threat. That's one issue in the case, and that wouldn't matter if he had written a letter by snail mail or if he had posted online, same legal issue. The second question is, in figuring out whether even a reasonable listener should take the language as a threat, does the context of online matter? Because online speech just tends to be, wilder and tends to be less constrained and people don't post it with the same sort of seriousness with which they used to put pen to paper. And is that a factor that has to be taken into consideration in deciding whether or not this language represents a threat? And that's what the court's going to be deciding.
Let me ask you about Walker v. Sons of Confederate Veterans.
You've just been waiting, haven't you?
I have. It's one of my favorites. Explain the case. It has to do with license plates,
right,
with Confederate flags on them.
Right.
The ACLU says
that they have the right to their flag with their Confederate license plate.
Issued by the states.
As every license plate is issued by the state. But
isn't that giving a stamp of approval to something that is hate speech?
No,
to many millions of people in this country?
No, there's no doubt that the Confederate flag is a symbol of racism to many people in the country, and we said that in our brief, and fundamentally offensive and good for Texas in a rare moment of reasonableness has recognized that. But you have to understand both the way these specialty license plate programs work and also a little context and background to understand how the ACLU took the position that it took. And that is, states have figured out that the license plate is like a billboard. It's a way to make money by selling space on the license plate so that people can put their own individualized message on top of, in addition to the message that the state has on the license plate, which is the state motto and your registration, your license plate number. The rest of it, they've decided, is space that we can sell. And once the state decides that it's space that we can sell and will basically allow anybody to put a message on their license plate who sort of pays the fee to the state to get that specialty license plate, then basic First Amendment principles say that the government doesn't get to pick and choose the ideas that it likes. And to understand the consequence of giving the state that authority, you have to understand that the other big context in which this issue arose and what really brought the ACLU into the controversy and into this case in the Supreme Court has to do with abortion rights. And we have states around the country that have specialty license plate programs in which they will issue specialty license plates that say pro-life, and they will not issue specialty license plates that say respect choice. And our position in that case was the state doesn't get to pick and choose in that way, and if it doesn't there, it doesn't end the Confederate license plate case.
You lose some support every time you take one of these positions. You say don't compare it to Skokie, but isn't it like Skokie? Isn't it like letting the Nazis walk through a Jewish community where it's hateful, hurtful speech?
Well, it is hurtful speech. I think the magnitude is not the same, and I don't think we lose support.
So the ACLU has not joined the Confederacy?
I think that the ACLU has not joined. We're on the winning side. You know that, right? But I think the ACLU gains respect for taking a principled position over time, even in unpopular cases, and maybe that's what we've done here. But that's what the ACLU does.
Well, I can't tell you how glad we are to have you here, and as always, there is never enough time to talk to you. We are too soon out of time. But as always, we thank Steve Shapiro, National Legal Director of the ACLU, for bringing his knowledge and unique perspective here to due process. It's the kind of public interest programming on serious issues of law and justice you won't find elsewhere.
So we hope you'll join us next week and every week on 13 and NJTV, and let us know what you think about the justice issues that affect your life. Visit us on Facebook or our website, where you'll find our entire due process archive on demand. For Sandy, producer Tanya Bentley, and all of us here, I'm Raymond Brown. Thanks for watching.
There's a provision in the law that says federal subsidies or tax credits for low and middle income Americans are available only on exchanges established by the state. They claim that that does not include subsidies for purchases on exchanges that the federal government creates.
In 34 states, the insurance marketplaces are entirely run by the federal government because state lawmakers opted not to set up their own. If the court wipes out financial help for those shoppers, the number of uninsured is expected to rise by 44%. The fallout would be heavily concentrated in the South. Estimates show that of those who could become uninsured, 62% live in southern states and 61% are white.
Want even more insight on law and justice? Become a fan of Due Process on Facebook. Follow us on Twitter and watch us on demand on YouTube.